Beginning in 1857, discrimination against African Americans became huge. The Supreme Court decided to hold that whether enslaved or free, African Americans could not be citizens of the United States. Chief Justice Taney stated that when the Constitution was adopted, African Americans were not considered of high authority like the white man. They were considered to have no rights, which the white man was bound to respect. This led to the second-class citizen treatment they were to receive in the future. This second-class treatment led to an act of Congress on March 3, 1865. The Bureau of Refugees, Freedmen, and Abandoned Lands, or the Freedmen's Bureau, had a mission to help freedmen become more aware in more areas than one to be set for life. The schools that were set up would eventually train and graduate majority of the people that were included in Plessy.
Homer Plessy, 7/8 white and 1/8 African American, purchased a train ticket with Louisiana. When he boarded the train, he sat in a car reserved for white passengers. He was eventually arrested and charged for violating the Separate Car Act, not moving to a car for African Americans. During Plessy's trial, Judge John H. Ferguson ignored the dispute, stating that the act was not unconstitutional. Later, oral arguments were heard on April 13, 1896, but the decision of the court was pushed back a month later on May 18th. It was decided that Plessy's argument did not violate the 13th or 14th Amendment. The train incident did not create a problem with the 13th Amendment because it didn't reestablish slavery, and the same goes for the 14th Amendment. The social equality was not secured by the amendment like Plessy described. It only protected legal equality that would be respected because of the accommodations due to the idea of being equal. While Plessy was speaking on the violation of the amendments and the Constitution itself, Brown responded by saying the Separate Car Act was meant to hold public peace and good order, meaning the legislature's police power had a reasonable cause to enforce the exercise. Associate Justice John Marshall Harlan made the decision that the court was ignoring the obvious purpose of the Separate Car Act, which was to give blacks and whites equal accommodations while traveling. However, the act isolated African Americans, imposing a stamp of servitude which was a violation of the 13th Amendment. The law messed with the freedom of all races because it limited the rights of the citizens. Due to the limited rights, the act disagreed with the principle of equality, which was the 14th Amendment's clause. Harlan wrote that, "Our Constitution is colorblind, and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color when his civil rights are guaranteed by the supreme law of the land are involved." Between the years of 1908 and 1951, more cases led to the Brown v. Board of Education case. There was a case in Kentucky where the state law didn't allow interracial instruction at all schools and colleges. The tool that helped this and many other attacks on segregation was the NAACP. The NAACP was made to eliminate lynching and to fight racial and social injustice primarily through legal action. This was founded by W.E. Du Bois, Ida Wells Barnett, and Mary White Ovington. This organization would eventually be used to try the Brown v. Board case. Courts began to apply the separate but equal formulation to most, if not all, trials dealing with public schools. These trials included the Gong Lum v. Rice, State of Missouri ex rel. Gaines v. Canada, Sepua v. Board of Regents of University of Oklahoma, Briggs et al. V. Elliott et al., Sweat v. Painter, McLaurin v. Oklahoma State Regents, and lastly, the Bowling v. Sharp cases. These all led up to probably one of the biggest cases in America, the Brown v. Board of Education case, filed in Federal District Court in Kansas on February 28, 1951.
The effort to desegregate public schools across the United States was a crucial goal of the civil rights movement. In August of 1951, it was held that no willful intention or substantial discrimination lived in Topeka's schools. Both the white and black schools were comparable by the physical appearances. This is where American integration began. African Americans were expected to abide by the law stating that they were not allowed to share the same schools, buses, and other facilities, also known as Jim Crow laws. The NAACP spoke out against the segregation laws in public schools and filed plenty of lawsuits concerning the topic. One of the most important and famous lawsuits would be filed in Topeka, Kansas by Oliver Brown against the Board of Education. Oliver Brown was dropping his daughter off at school when she was denied entrance to the all-white elementary school. He stated that the school for each race weren't equal like it states in the Equal Protection Clause of the 14th Amendment. When the case was taken to court, it was agreed that the segregation had a detrimental effect upon the colored children, but they still stuck to the separate but equal doctrine. More cases were related to Brown's case, so the court grouped them all together. At first, Chief Justice Fred M. Vinson was still holding the opinion that the Plessy verdict should stand. However, in September 1953, Vinson died, leaving Dwight D. Eisenhower to replace him and Earl Warren for governor of California. With such skill in politics and determination, Eisenhower had a unanimous verdict against the school segregation. On May 17, 1954, it was stated that in the field of public education, the doctrine of separate but equal has no place by Warren himself. It was later decided that the plaintiffs were deprived of the equal protection of the laws guaranteed by the 14th Amendment.
And reminisce with me some 50 years ago when my family became part of Brown versus the Board of Education. It all started for me on a balmy day in the fall of 1950 in the quiet Kansas town of Topeka, when a mild-mannered black man took his plump 7-year-old daughter by the hand and walked briskly 4 blocks from their home to the all-white school and tried without success to enroll his child. The child of whom I speak was I, Linda Carroll Brown, and my father, the late Reverend Oliver Leon Brown. Black parents in Topeka felt that the day of trying to enroll their children in the school nearest to their home was long overdue. Many were the evenings my father would arrive home to find my mother almost in tears because I would get halfway to the school bus stop, which was a 7-block walk from my home. I could only make half that walk because the cold would get too bitter for a small child to bear. I can still remember starting that bitter walk and the terrible cold that would cause my tears to freeze upon my face.
Until the court's decision, many states across the nation had mandatory segregation laws, requiring African American and white children to attend separate schools. The Little Rock Nine were a group of 9 black students who enrolled at formerly all-white Central High School in Little Rock, Arkansas, in 1957. Minnie Jean Brown, Elizabeth Eckford, Ernest Green, Thelma Mothershed, Melba Patillo, Gloria Ray, Terrence Roberts, Jefferson Thomas, Carlotta Walls have been recruited by Daisy Gaston Bates, president of the Arkansas NAACP, on September 2, 1957. Governor Orville Faubus announced that he would call in the Arkansas National Guard to prevent the African American students' entry to Central High, claiming the action was for the students' own protection.
The Little Rock Nine arrived for the first day of school at Central High on September 4, 1957. Only 8 arrived together. Eckford arrived alone. The Arkansas National Guard, under orders of Governor Faubus, prevented any of the Little Rock Nine from entering Central High. One of the most enduring images from this day is a photograph of Eckford, alone with a notebook in her hand, approaching the school as a crowd of hostile and screaming white students and adults surround her. A few weeks later, federal judge Richard Davies began legal proceedings against Governor Faubus. President Dwight D. Eisenhower attempted to persuade Faubus to remove the National Guard and let the Little Rock Nine enter the school. The following day, President Eisenhower sent in 1,200 members of the U.S. Army's 101st Airborne Division from Fort Campbell, Kentucky, and placed them in charge of the 10,000 National Guardsmen on duty. Escorted by the troops, the Little Rock Nine attended their first full day of classes on September 25th.
Although several of the black students had positive experiences on their first day of school, some experienced routine harassment and even violence throughout the rest of the year. Gloria Ray was pushed down a flight of stairs, and the Little Rock Nine were prohibited from participating in extracurricular activities. It was not only the students who faced harassment. Gloria Ray's mother was fired from her job when she refused to remove her daughter from the school. The 101st Airborne and the National Guard remained at Central High School for the duration of the year.